76 Rebel, and there I represent for CVM. See it happen.
Tonight on Lead Story, the Supreme Court has dismissed an application brought by the Firearm Licensing Authority, FLA, in its ongoing legal challenge against the Integrity Commission. The FLA had sought judicial intervention to prevent the tabling and discussion in Parliament of an Integrity Commission report examining allegations of corruption, impropriety and irregularities in the grant, variation and revocation of firearm licenses, as well as the storage of firearms and ammunition at the agency. The matter arose from judicial review proceedings filed by the FLA against the Integrity Commission and its Director of Investigations, Kevin Stevenson. Among the issues before the court was whether the report should be disclosed to the court before being tabled in Parliament. The FLA argued that the court could not properly consider the judicial review application without first examining the report. When the matter came before the Supreme Court, attorneys for the FLA contended that provisions of the Integrity Commission Act allowed the court to obtain a copy of the report for the purpose of the proceedings. They also sought orders aimed at preventing Parliament from tabling or discussing the document while the legal challenge remained before the courts. The nation's Parliament chose not to table the Integrity Commission report on the affairs of the FLA before today's ruling was handed down. This sparked public controversy. But the court ruled on the matter today and dismissed the application. However, the court also granted the FLA leave to appeal the decision, paving the way for the matter to be considered by the Court of Appeal on September 17. We'll get reactions to today's significant ruling. Also tonight, the Court of Appeal earlier today overturned a professional misconduct finding against attorney at law and Eastern Portland Member of Parliament, that's Isaac Buchanan. His attorney, John Clark, was supposed to join us. I think we're being joined by Isaac Buchanan himself. I'm Tyrone Reed, sitting in for Jody and Quarry, and this is Lead Story. Well, joining me now to examine this significant court ruling is Nico Pagan, the attorney representing the FLA. Top of the evening to you, Nico Pagan. He joins us on the phone. Mr. Pagan, welcome to Lead Story.
Oh, thank you. Thank you for having me.
Nico Pagan, help our viewers locate this ruling. What does it mean for the FLA?
So the first thing we need to understand is the nature of the application which was before the court. The application was one for the report to be released in the court proceedings and to the parties because the FA is challenging the report itself. Good?
Yes. We
say, and this is a concept that is well known and well settled, that public body has in judicial review proceedings, the parties usually would disclose information. We thought that it was necessary for the report to be released in the court proceedings so that the court could properly determine the matter. The court believed that it was not necessary and that the report should remain confidential because the court can hear the judicial review proceedings without seeing the report. What the court also ruled on is that because the issue of whether or not the report should be released in the judicial review proceedings was another one that FLA was is now allowed to go to the Court of Appeal to have the Court of Appeal give an opinion on this matter. What I need to make very clear is that there was nothing before the court that concerned the issue of any tabling of the report in Parliament. So that was not a matter that was up for discussion any at all. I trust that should assist your listeners.
The Supreme Court, the Court Administration Division rather, issued a statement, Nico Pagan, on today's ruling. And it says that and for the benefit of the viewers as well, it says the Supreme Court has refused an application by the Firearm Licensing Authority seeking disclosure of an investigative report prepared by the Integrity Commission concerning alleged corruption, impropriety, and irregularities in the storage of firearms and ammunition and the award of firearm licenses at the authority. In a ruling delivered by Justice Tara Carr in Chambers, the court determined that the report remains confidential under the provisions of the Integrity Commission Act until it is formally tabled in Parliament. For those who are not as legally trained as you are, Mr. Pagan, that seems to be suggesting that the Parliament must table the report before it can be aired in open court. Is that your understanding of the ruling?
No, my understanding of the ruling is that at this stage of the proceedings where we are, which is leave to apply for judicial review, the court does not think it is necessary for the report to be released to the court for the purpose of determining that application, which is to be heard later this year.
And do you consider this a win for the FLA?
It is a neutral position at best. One would imagine that it could be a win in the sense that the court believes that we can still go on to judicial review without the report and for the report to remain confidential. In that regard, yes, I would say.
Well, the statement from the Court Administration Division, I want to read another section of it to you to get your reaction to it. It says, Justice Carr also rejected submissions that the report fell outside the confidentiality provisions of the Integrity Commission Act. The court concluded that reports prepared pursuant to Section 54 of the Act remain subject to the confidentiality requirements imposed by Section 53(3) until they are tabled in Parliament. So, again, the point I put to you about the need for the document to be tabled in Parliament before it can be tabled in open court seems to be supported by this section of the release from the Court Administration Division.
I understand that. I've not seen that. I can only speak to what my understanding of the judge's ruling, which was delivered orally today.
And I can appreciate that, but based on what the Court Administration Division is saying here, you're saying you understand why that conclusion could be drawn, that the document must first be tabled in Parliament before it can be aired in open court.
Well, the proceedings as they are now is at a stage where we're at the preliminary stage of the judicial review proceedings. And so I would say, since we have obtained leave to appeal to the Court of Appeal on this matter, I will leave it at that for now and take that win and obtain the benefit of the opinion of the Court of Appeal on this issue.
The nation's parliament took the decision not to table until this matter was heard and a determination made. What is the FLA hoping for? What are your clients hoping for? Are they hoping that the document will remain untabled, or are you open to the document being tabled?
I cannot speak to that any at all. What I can say is that my client is pursuing what the law allows it to pursue, which is judicial review, and the act itself that governs the Integrity Commission allows the court to have full supervision over the Integrity Commission to include any actions which a person believes, and that includes any report that is prepared that is either in breach of the Integrity Commission Act, reach fairness, which everybody is entitled to, and if it is done contrary to law.
For your benefit and for the benefit of the viewers, Mr. Pagan, the Court Administration Division's media statement issued today after the ruling, says the judge noted that the legislation expressly criminalizes unauthorized disclosure of confidential investigative material and held that it would be inappropriate for the court to order disclosure in circumstances where Parliament had prescribed a clear statutory process governing confidentiality and tabling. Accordingly, the court refused the application for disclosure. So the court refused the application for disclosure. That is your understanding of it, that the court is saying we can't disclose what's in this document until the parliamentary process is concluded.
My understanding is the court applied the confidentiality clause in that regard. However, in our application for leave to appeal, we indicated that under the same act itself, there is a provision which actually allows for the conduct of proceedings and subject the confidentiality clause to that provision. That provision is section 53(4). Which says that nothing in the confidentiality clause precludes the conduct of any proceedings before the court or the taking of administration action. We say that this is court proceedings, and so the court is empowered in that regard. And we said that that was a consideration the court ought to have taken into consideration, and it did not.
How would you respond to those who might suggest, Mr. Pagan, that any notion that the FLA can consider this ruling a win is wishful thinking because the court refused the application for disclosure? How would you respond to those who are reading the court ruling like that at this hour?
So again, my response to this is a neutral position here, because what the court has in fact done is to say, well, based on the points you have raised now, we think that you can go ahead with your judicial review proceedings without the report. But anyhow, here I am giving you permission to ventilate this novel issue in the Court of Appeal. And so it doesn't stop here. The Court of Appeal may come to a different view on the issue of whether or not the report should be released for the purposes of the proceedings and for the court to hear the matter.
But isn't one of the major asks before the court that your team put before the court is the disclosure? Isn't that one of the major planks?
I wouldn't say no.
You would say?
No.
You would say no. Well, all right. So the substantive application for leave to apply for judicial review is scheduled for hearing on September 17, 2026. And your team will definitely be following through with that.
Correct.
Thank you so very much, Nico Pagan, attorney at law representing the Firearm Licensing Authority. I appreciate the time and the thoughts.
You're welcome.
Indeed. All right. This is the lead story. We take the break right here and come back with more reactions to the Supreme Court ruling on this FLA matter.
Brilliant. Worth every penny.
Haaland into a rally.
A step over there, he walks past him, and then it's just a bit of magic.
Opening up for a shot for Moises Caicedo. The unthinkable unfolds before our eyes. Hey, what I want?
Hi, I am Candy Pagan.
What a guan?
What a guan?
That a guan pa.
What a guan?
What a guan?
What a guan? Mondays, Wednesdays, and Fridays at 8 a.m., 1:30 p.m., and 10 p.m. on CVM TV.
That's a guan pa. What a guan?
Jamaica's unemployment rate has fallen to 3.3%, down from 13.2% in 2016. Our government's continued focus on job creation is delivering real results. We are building Jamaica. The Time by the Office of the Prime Minister.
Welcome back to Lead Story. Joining me now are attorneys at law Alexander Shaw and Seymour Stewart. Good evening, gentlemen. Thanks for joining the Lead Story tonight. Let's begin with you, Alexander Shaw. Your immediate reaction to the court's ruling on the FLA matter?
Well, it comes as no surprise. The court is usually reluctant to perform an anticipatory review, and so in this particular situation, it would have been quite unusual for the court to grant the relief being sought by FLA.
Seymour, are you with us?
Yes, I'm hearing you.
Yes, I'd love to hear your reaction, Seymour Stewart, to the ruling.
No, I agree with my colleague. It's not a surprise. This matter, or a matter similar to this, was litigated a few years ago. I think it was Ian Hayes who asked the court to block the publication of a report into allegations of corruption and so on and so forth. Similar thing here. The judge ruled that she could not block Parliament from tabling a report. That's Parliament's business. And it's surprising that the FLA, of course, because I can't see how the judge would have ruled any other way. The law is quite clear. The Integrity Commission Act is quite clear. The court ruling is there as a precedent. And it's not understand it. I mean, what the Parliament is relying on, the standing orders, they don't apply either. So if they were to just look at the precedent from 2022, I think the ruling was, they would have seen that the court could not have ruled in any other way.
Alexander Shaw, how do you view the decision taken by the Parliament, the officers of the Parliament, against, again, another ruling that says Parliament has the power to table the reports and they need not restrict themselves? How do you view the decision of the Parliament against today's ruling?
Well, today's ruling is not necessarily in conflict with what Parliament has done so far, because what Parliament has maintained is that it's really striving for impartiality and to preserve judicial independence, because what we do know at this juncture is that the judicial review will be heard very soon. And so until that matter is decided, it does not want to prejudice or cause any unnecessary discussions about something that the court will treat with, and it perhaps wants the court to take an independent position. Not to say that the court's interpretation will be somehow influenced by Parliament's discussion, but that is the purpose of the sub judice rule, so that matters that are before the court are not to be discussed generally, but the court cannot interfere. As it stands, and as counsel has indicated, the court cannot tell Parliament, oh, you can't table the report, or you should table the report. So I am of the view that the two decisions are not incongruent to each other.
But let me stay with you on that point, Alexander Shaw. How is it in sync with each other if the court is saying we can't do anything about this report in terms of disclosure, because that was being asked for as well, that we can't deliver any judgment because we would have to disclose the details of this report, that we can't before it is tabled in Parliament. So if Parliament says we are not tabling, how is the court ever going to be able to rule on that matter concerning what is contained in the report?
Well, today's matter concerns disclosure for a judicial review that is to come. So what the court is saying is that based on the Integrity Commission Act, we cannot force the Commission to engage in disclosure when the law stipulates that such practice is criminal and in breach of the legislation. So if Parliament wants to table the report, Parliament can very well table the report. But if Parliament refuses to table the report, we can't tell Parliament what to do. So it is on that basis why I'm of the opinion that, it is for Parliament to make a decision, but not that today's ruling is saying that, Parliament did not do what is proper.
Seymour Stewart, I want to hear your opinion on your learned colleague's position there. But before you do, let me just read a couple of statements to you from a media statement issued by the Court Administration Division. It says, in a ruling delivered by Justice Tara Karen Chambers, the court determined that the report remains confidential under the provisions of the Integrity Commission Act until it is formally tabled in Parliament. In refusing the application, Justice Carr held that the court already had sufficient information to determine the issues arising at the leave stage, and that disclosure of the report was therefore unnecessary at this point of the proceedings. Went on to say the court concluded that reports prepared pursuant to Section 54 of the Act, that is the Integrity Commission Act, remain subject to the confidentiality requirements imposed by Section 53, subsection 3, until they are tabled in Parliament. The judge noted that the legislation expressly criminalizes unauthorized disclosure of confidential investigative material and held that it would be inappropriate for the court to order disclosure in circumstances where Parliament had prescribed a clear statutory process governing confidentiality and tabling. Accordingly, the court refused the application for disclosure. Do you share a similar thought process to your learned colleague Alexander Shaw, Mr. Seymour?
Not entirely, but I'll come back to that. You've omitted a part of the press release. Allow me to just read a part of it. The court found that the FLA was already aware of the nature of the investigation, the decision makers involved, and the grounds upon which it intended to challenge the process. I mean, what more did they want? I'm not sure that the court cannot tell Parliament what to do, because I've read recently where I read an article in a newspaper where I think the opposition leader was threatening to take legal action to compel Parliament to table the report. Yes. The court can compel Parliament to, and Parliament would be obliged to follow the ruling. Recall that the report was tabled, I think, at the end of March, and now we're at the end of May, and the Act speaks to the tabling of such reports without delay, effectively. And this is seen as being a very long delay. And seen by some, I'm not saying it's my view, but seen by some as a ruse to delay what is going to be the inevitability, i.e., because at some point it has to be released. At some point. There may be an appeal from this ruling today. We don't know. But if the Parliament continues to take the view that it does, that it will be in breach of the standing orders and so on, then legal action may have to be taken. And this is where I depart from my learned friend, that the court may well tell Parliament, or may well, Parliament may have to bow to what the court said.
Well, we're almost upon our next break. But I want to stay on that point that you are touching on there about the court being able to instruct the Parliament. In the previous ruling on a similar matter involving Ian Hales, which you mentioned, Seymour Stewart, the court expressly said that he didn't want to encroach on Parliament's authority. We're not hearing you, Seymour Stewart. Go ahead, Alexander, because we're not hearing Seymour Stewart.
Is that...
Yes, that so indeed, you're correct.
All right, 1 second. All right.
You're correct.
Go ahead, Seymour.
No, you're correct. I think it was paragraph 60 of the judgment where the judge expressly said that in no uncertain terms.
Right.
That the court will not interfere with what the workings, as it were, of the Parliament.
So doesn't that put to the sword your argument that the court can't tell Parliament what to do? That's my argument to you.
No. If the court makes a ruling on something that Parliament is supposed to do, but has not done, it doesn't. Why can't they? Why do you think that the court would have no power to compel Parliament? Parliament is not a rogue organization. It is subject to the Constitution and the laws of the land.
But isn't the court respecting the separation of powers doctrine by saying we don't want to encroach on the legislature? Isn't that what the court is doing by saying that?
This was not a matter to do with separation of powers, in the sense that you're describing it. It's a matter to do with the separation of powers in the way the separation of powers is supposed to work. All the judiciary is meant to be independent, and let me say this: so we are lucky to be in a country like Jamaica, because I don't see where we can say the judiciary is not independent in Jamaica. We can say that in many other countries. In fact, many other countries, some of them much richer and more prosperous than ours. But from what I can see, I think we have a robust judiciary and we can be proud of the independence of our judiciary. So I don't agree with that. As I said, Parliament is not a body unto itself, on an island unto itself, which can just do whatever it likes. Remember, Parliament, the court has struck down pieces of legislation,
which they have, because that is their domain on the separation of powers. Isn't that so? Yes. Right, to interpret laws. We're up on a break, gentlemen. I know Alexander Shaw must be champing out the bits to come back in. Let's take the break right here, and when we come back, we'll continue to get reactions from Seymour Stewart and Alexander Shaw to this significant Supreme Court ruling refusing Jamaica's gun authorities' application for disclosure of an Integrity Commission investigative report into its affairs.
The internationally acclaimed On Stage with Winford Williams.
At a new time, Saturdays at 8 p.m. on CVM TV.
So much more than entertainment.
Jamaica. Make we do the right thing. Make we live good today for a better tomorrow. Talk it out. Don't fight it out. The time by the Ministry of National Security is
6:30.
Thanks for staying with us. This is Lead Story. If you're just joining us, of course, welcome. I'm Tyron Reed, sitting in for the erudite Jodian Quarry. We are getting reactions to the Supreme Court's decision to refuse Jamaica's gun authority's application for disclosure of an Integrity Commission investigative report into its affairs. Alexander Shaw and Seymour Stewart are with us. Thank you, gentlemen, for sticking and staying with us. We appreciate the time and the thoughts. Alexander Shaw, you wanted to come in just before the break. Alexander Shaw?
Yes, and I wanted to make the point, Tyrone, that disclosure is usually a part of our court proceedings. And so that is why the FLA was seeking to advance the argument that it needs disclosure in order to prepare for the judicial review that is to come in September. What the court has said is that to grant that review would be a breach of not just the Integrity Commission Act, but it would get in the way of Parliament, because why is it, earlier I said it was an anticipatory review, and the reason I'm saying that, or the reason I said that, is because the report has not yet been tabled in Parliament, and so for the court to grant disclosure, it means the court would be in breach of Parliament's internal procedures, which would be in breach of the Constitution, which we're speaking now generally about the separation of powers doctrine. So the Parliament is saying that, listen, because of the judicial review slated for September, we don't want to table the report. Let's wait until the matter is...
Well, not for September, for May, for 29, today. That's what they said. The September date was set today, no?
Well, yes, but today was just for the disclosure, to see whether or not a disclosure could be made of the report.
And help us to understand, Alexander Shaw, when you say disclosure, what exactly is the Firearm Licensing Authority asking for? Disclosure of what?
Disclosure of the report, so that it can, because no, the report, based on the Integrity Commission Act, the report has not been disclosed on the FLA.
Because it's not been tabled in Parliament.
Because it has not been tabled in Parliament. And to disclose it to the FLA, the Integrity Commission would be committing a criminal offense here. But the Integrity Commission is saying that we need the report so that we can prepare. The court is saying, no, you already know the grounds on which you're going to proceed with that application.
Which is the point your learned colleague was making when he pointed out that a section of the report I didn't read that said the court found that the FLA was already aware of the nature of the investigation, the decision makers involved, and the grounds upon which it intended to challenge the process, including allegations of procedural unfairness and illegality. Justice Carr stated that the judicial review proceedings are primarily concerned with the decision-making process of which the applicant was already aware. In layman's terms, what does that mean, Alexander Shaw?
In layman's terms, so they're saying, listen, you don't need the report. You are the ones who are saying you're going to challenge the commission based on how it investigated and made certain decisions, right? You already know your grounds, so you don't need a report to fix your case. You're the one making that challenge.
Right. And if we disclose this report in open court before it is tabled in Parliament, we'll be committing a breach of the Integrity Act, Section 53.
And then we're going to get in the way of Parliament, because Parliament, the current Parliament is saying we're not tabling the report. So we can mandate Parliament to table the report.
So doesn't that take us back to the very major issue that Alexander Shaw, Parliament needing to table the report?
Well, Parliament is saying that, listen, what we have done in the past is, in 2017, we did not table a report because there was a pending legal matter. And so the procedure we're adopting is that we will not table the report, even though it may not be written. We as a parliament is making that decision based on precedent.
Let me bring Seymour Stewart back into the conversation. Seymour Stewart, the statement from the Court Administration Division went on to say that the court further held that the Integrity Commission had satisfied its duty of candor by providing sufficient information regarding the investigation and the process undertaken. I asked the attorney at law representing, one of the attorneys representing the FLA, if he would consider this a win. He said in a certain sense, he would. Would you consider this a win for the FLA, or was this a win for the Integrity Commission? Seymour Stewart?
Well, we don't really, we as lawyers don't speak of winning. That's what other people do. But this was, well, if there's a winner today, it would be the course of justice. If there was a winner today, because, as I said, it's quite clear. The court could not have ruled any other way based on the circumstances. I mean, if you look at it in the round, what is it that the FLA wants to? What is the effect of what the FLA is doing? The effect of what the FLA is doing is to delay the tabling. And let me correct myself. I think I said it was tabled in March. It was submitted.
Submitted, yes.
What it is, what the effect of what they're doing is to delay a report which alleges very serious business, corruption, and all sorts of things that people find interesting, or the public would find interesting in Jamaica and in other countries. So that's the effect of what they're doing. It is delaying it. I mean, let's look at what the Parliament is saying. The Parliament is relying on the sub judice rules. The sub judice rules do not apply. The sub judice rules apply to trials. There's no trial. There's no trial at all. So I'm not entirely sure how it is that the Parliament could be standing, as it were, on the standing order that they are relying on, because it just does not apply. So the effect of what is happening is that the report, the table, Parliament has taken it upon itself, or the Speaker, to delay
the officers of the court, not just the Speaker, the officers of the Parliament, which would include the President of the Senate as well. And I gather that was in consultation with the Clerk of the Parliament, the Clerk to the Houses.
Well, you are quite correct. Parliament, the Speaker, and the President. That's how it is.
Yes.
Referred to. So you are quite correct. So that's the point I'm making. Where it's delaying the matter and maybe kicking it into the long grass for some of the time. We don't know, but it is for some people it just beggars belief.
Let me ask you pointedly: were the nation's Parliament to continue along this road with this decision not to table until after September now that we've gotten this ruling from the Supreme Court, if they were to kick the can down to September 17, Seymour Stewart, would you consider that continued suppression of an investigative report by the nation's Parliament?
Yes. I mean, what else could it be? I mean, some others may take a different view, but you've asked me a direct question. I'm giving you a direct answer. I think it would be so considered.
Alexander Shaw, I'd love to hear you on that. You heard your colleague. He's saying, look, Parliament is muscling itself. The sub judice rule doesn't apply. This is not a trial. How do you respond to that, Alexander Shaw?
I don't necessarily agree with my learned friend, and it's primarily because the Integrity Commission has immense powers, investigative powers. And when we have to bear in mind that Parliament is privileged, whatever is said in Parliament, even when it damages your character in the most significant and irreparable way, you really can't get any sort of relief. And so if there is a motion or if there is an action to challenge the way in which an investigative body went about and conduct itself, then I believe that it is not improper to allow the court proceedings to continue and to be determined so that whatever is said and done, we don't rush to conclusion. Because the very moment things are said in Parliament, Tyrone, people will draw a conclusion without, determining whether or not the Integrity Commission was fair. And so I believe at this juncture, it is what is happening now in terms of the court proceedings is very important for jurisprudence, because we will only build and learn from these experiences.
But Alexander Shaw, wasn't this matter settled in the Ian Hales case?
Well, in Ian Hales' case, I don't think so. And I tell you why. Because what is being examined here is whether or not the actions of the Integrity Commission were procedurally improper and illegal. That is the basis on the grounds on which I understand the FLA to be challenging the Integrity Commission. No, that has not been determined, Tyrone. And so that needs to be determined so that when Parliament ventilates and debates the report, whatever conclusion is formed is justified. So the Ian Hales matter is saying Parliament is not, the court is not going to interfere really with Parliament. Let Parliament decide how it's going to operate. But
it can come down to whether or not Parliament is doing the right thing, Alexander Shaw. And in this matter, there are many people who don't think the Parliament is doing the right thing. If the Ian Hales matter took about 5 years before that report was actually tabled in Parliament, and that report, of course, was put together by the then Office of the Contractor General, of course, one of the entities subsumed into the Integrity Commission. Should this present matter with the FLA take another 5 years? The old maxim says justice delayed is justice denied. If it takes 5 years, Alexander Shaw, wouldn't that be seen or rightly be seen as the suppression of an investigative report via the courts?
Because what the Parliament has said is that it's awaiting the court's decision. So Parliament's decision is dependent on the court. No, we need to have a broader discussion. Court matters need to be determined in a much earlier time so that justice is not denied.
So it can be that people are abusing the delay that they know are embedded in the system.
Well, we need to work on getting our court matters expedited so that justice can be served. Justice delayed is justice denied.
I give you the final word, Seymour Stewart, on this matter.
I would just comment paragraph 60 of the Ian Hales case, because to answer your question, Tyrone, yes, the matter was settled. It has never been appealed, and it is not an appeal. It was settled, quite clearly settled. The Speaker of the House and the President of the Senate, the judge said, would have been acting intra vires, i.e. within their rights, by tabling the report submitted by the Contractor General, as it then was. Their actions would be categorized as Parliament conducting their internal affairs, and as such, their actions would be immune from the jurisdiction of the court. That's what it's saying. I can't see the difference here. I really can't see the difference here.
Seymour Stewart. Oh, no, sorry. Complete your thought. I give you a complete your thought. You can't see the difference?
I was just, I've completed, I was just going to say, what the judge said finally. I find that the Speaker of the House and the President of the Senate were improperly joined to the application for leave as interested parties. That's to do with an where they joined the Speaker and the President of the Senate to be a part of the case. The judge says, oh no, Parliament is doing its business.
We are out of time. We have to leave it there, Seymour Stewart. My producers are telling me I'm out of time. Thanks to Seymour Stewart, Alexander Shaw. Thanks to both of you gentlemen for taking the time to be with us. This is the Lead Story. We take the break and come back with more. Say it again.
The internationally acclaimed On Stage with Winfred Williams.
At a new time, Saturdays at 8 p.m. on CVM TV.
So much more than entertainment.
Let's delve deep into the issues. We'll take you beneath the surface.
Greetings and salutations. My name is Orville Higgins and it's another edition of Fan Central.
Talking to the people at the heart of the top sporting stories. Hear from your favorite sportsmen and women and the administrators who work tirelessly to make it all happen. It's live sports talk.
I've written an entire article.
Yes.
Looking at all the major issues every Tuesday at 9 p.m. It's Fan Central.
Welcome back to Lead Story. We end tonight with another legal matter that dominated headlines. The Court of Appeal earlier today overturned a professional misconduct. Isaac Buchanan. The matter arose from comments he made about former Director of Public Prosecutions Paula Llewellyn back in 2020. According to a report published by the Gleaner newspaper, in the ruling this morning, Jamaica's appellate court said the disciplinary committee of the General Legal Counsel acted unfairly and in breach of natural justice in dealing with certain aspects of the case and erred in law when it found him guilty of misconduct conduct on becoming his profession. The unanimous judgment allowed Buchanan's appeal in full, setting aside both the October 1, 2022 misconduct finding and all sanctions imposed by the committee on October 22, 2022. The GLC, which regulates the legal profession in Jamaica, was ordered to pay Buchanan's legal fees. The appeal was heard last November by Justices Paulette Williams, Marcia Dunbar Green, and Evan Brown. This case is separate from another GLC-related matter involving comments Buchanan made about the DPP in 2023 and for which he was sanctioned. He pleaded guilty but appealed the 2-year suspension sentence, which was put on hold by the Court of Appeal in December 2023. The matter that was ruled on today arose from a November 2020 interview Buchanan gave to Loop News, a now defunct online news website, while representing dancehall artist Adidja Vibes Cartel Palmer in a Privy Council appeal against his murder conviction. In the interview, Buchanan was quoted describing the Office of the Director of Public Prosecutions as, quote, very dodgy and shady and very deliberate in their action to continue to violate the constitutional rights of Adidja Palmer amid a prolonged dispute over access to a mobile phone exhibit central to the defense team's case. Isaac Buchanan joins us now. Isaac Buchanan, thank you for joining Lead Story tonight.
Good evening to your viewers and listeners.
Good evening to you. I know we heard from two of your learned colleagues just now that lawyers don't like to say whether or not anyone has won a case. But do you think you are a winner this evening?
I think it's about lawyers don't win. I think for me, as a human rights lawyer, only the Constitution wins. So for me, natural justice won today, and the law won.
Natural justice won and the law won. And do you feel vindicated as an individual, as a professional?
You know, I think in the modern dispensation of social media, where things are a 9-day wonder, I'm learning that the court of public opinion needs to be revisited. Vindicated is not the word that I'll be looking for. I just know that as a professional, it's sometimes difficult to be cast in the misconduct category when you're doing the best at your job. I took on a case that was very controversial, and I think the remnants of that has, the verdict is out as to what it has done for my life. But to say that, I'm just happy that, you know, I went to the Court of Appeal, because I always know that the justice system works. And as a trained attorney, I too make assessments in terms of where the law is. And so it's not fighting, it's more so to advance the jurisprudence. Sub judice is a hot topic. The sub judice rule is a hot topic for journalists. And I wear both hats where those are concerned. So for me, I think that freedom of expression, it won today, as well as the sub judice rule. It recently in Parliament, that was flouted, and the clarity from the court in terms of how to treat with natural justice the standard for breaches of the sub judice rule, and whether or not it affects judges who are, trust me, they have judicial independence, and we expect a certain level of internal locus of control. I'm just going to say humbly that this was for persons who are expressing themselves with a genuine view, and that's what I'm happy about, the law.
In the courts, the Court of Appeals ruling, Isa Buchanan, it ordered that the GLC should pay your legal fees. Are you going to follow through with that?
Well, what I would say is it said cost. That's a question to ask about with John Clark. Cost usually is awarded to the attorney, so let's just dispel the mind that somebody's going to get some big money and there's some joy of vindication. The vindication, as you had noted, is just in relation to the professional stigma, and that's the end of that.
Just to be clear, for those who are watching and listening, Isa Buchanan, there are two separate issues involving the Office of the Director of Public Prosecutions, and you have the court has ruled in your favor on this particular matter. This one involved comments you made about the issue about gaining access to what you felt was a critical piece of evidence, and the comments that you made. But there's another issue that you pled guilty to. Could you remind us of that, and then tell us what's the latest on that?
I think this is where I would say, as a trained attorney, that matter is sub judice as it is before the court.
It's sub judicates before the courts. That's where it's at now.
Yes, my understanding of the sub judice rule is that I can't speak on it lest I be brought before the GLC. So I apologize.
And you don't want to be before the GLC too often, do you?
I never want to be sent to the GLC for breaching the sub judice rule. It's a sensitive matter.
And for other defense attorneys who might be looking on, what does this mean for zealously representing your clients? For
2026 will say that, you represent to the best of your ability, but you have to be mindful, respectful. You're not to let your emotions get the best of you. in this new dispensation. The nature of the profession in a social media space is equivalent to the call for police officers to wear body cams so we can see what is happening at all material times. Do your best, but do it respectful. Respect your colleagues no matter what. Try not to be discourteous or fall outside of the good graces, because 10 cases later, you may be sitting beside the very colleague who can assist you in court, because the law is that's why we call it the practice of law. So the GLC won today because guidance was brought from the court in terms of how we're to treat with matters in or outside of the court.
I have about 30 seconds left. Isaac Buchanan, I'd love for you to speak just quickly on the need for attorneys at law, officers of the court, to be judicious in their pronouncements. You touched on that. I'd love if you could just expound on that a bit more for us as we close.
I would just say this, that we have a duty to the court, just even through the canons and just for justice to be judicial. The law is not a lazy exercise. The law is actually a jealous mistress. So if we are to respect the law and make pronouncements consistent to the law, we'll be less embarrassed when, as long as our final court remains outside of Jamaica, we might be, we are calling on outsiders to make pronouncements on what I believe are competent judges and some of the brightest minds now run the court of Jamaica. We need to be respectful in terms of appreciating the importance of law and, most importantly, the Constitution. I'm happy that the court gave a judgment today, and they've done many other times.